Chevron stands wrongly accused of environmental and social harms in Ecuador, a country where it has never operated. The plaintiff's allegations are false and easily rebutted in light of the real facts. So the plaintiff's lawyers went so far as to commission a movie to spread their lies. The movie Crude is fiction, often rehearsed and even scripted. The film was bought and paid for by plaintiff's lawyers suing Chevron Corporation in Ecuador. They recruited a filmmaker to make their movie, funded the film, and exercised editorial control to further their scheme to extort billions of dollars from Chevron Corporation. New York attorney Stephen Donziger commissioned filmmaker Joe Berlinger to produce Crude, The Real Price of Oil, as part of a global public pressure campaign aimed at Chevron Corporation. Donziger helped Berlinger fund the film through his friend, internet poker billionaire Russell De Leon. De Leon told Berlinger that he hoped the movie would pressure Chevron Corporation to pay. Through his investment company, Torvia Limited, De Leon poured millions of dollars into the legal case, in hopes of earning hundreds of millions more. Through proceedings before a U.S. court, Chevron Corporation obtained unreleased footage from Crude, commonly known as outtakes, that was never meant to be seen outside of the edit room. As one U.S. court found, the footage shows with unflattering frankness inappropriate, unethical, and perhaps illegal conduct by the plaintiff's lawyers. Those outtakes also confirm that the plaintiff's lawyers had the power to stop the cameras at any time and to direct the filmmakers to exclude from the movie scenes they did not want the public to see.
By the way, whenever we want to push the edit button and dump these guys in the street, we can, but no, I'm friends with them. None of this is going to get in if we don't want it.
In essence, the subjects of the so-called documentary exercised editorial control.
You have to alter that a little bit.
Yeah, now there's another point. I got to make a point to these guys, but I can't get this on camera.
When confronted with evidence of their complicity, the filmmakers were forced to close the movie with an admission of plaintiff's control over the editing process. Crude tells a story that the plaintiff's lawyers know is false. They ignored their own environmental experts who told them Texaco Petroleum Company's remediation was performing as designed. Ignored studies showing that indigenous populations have been growing for decades. And made false claims about Chevron Corporation causing cancer and environmental harm. In Crude, the plaintiff's lawyers portray as independent the expert they bribed to file a report they themselves wrote. And while accusing Chevron Corporation of corruption in the film, behind the scenes they blackmailed, bribed, and coerced Ecuadorian judges and government officials.
The only language that I believe this judge is going to understand is one of pressure, intimidation, and humiliation. And that's what we're doing today. We're going to let him know what time it is.
They even go so far as to baselessly suggest that lead Ecuadorian lawyer Pablo Fajardo's brother was murdered by hitmen in a case of mistaken identity, when Fajardo himself told police that it was local thugs who murdered his brother in an alcohol-fueled ambush. The result is a fictitious propaganda piece, not a documentary. Texaco Petroleum Company, known as TexPet, ceased oil operations in Ecuador in 1990, and the government of Ecuador became the sole operator of the former concession through the state-owned company Petroecuador. From 1995 to 1998, TexPet spent 3 years and $40 million on remediation of its share of the former concession and community development programs, all of which were overseen and approved by the Ecuadorian government. After approving TexPet's remediation, the government of Ecuador formally released TexPet, Texaco, and their related corporations from any responsibility arising from its prior operations. Years later, TexPet became an indirect subsidiary of Chevron Corporation. Petroecuador publicly acknowledged its responsibility for remediating all remaining pits. The plaintiff's experts told Donziger TexPet's remediation had been successful and was performing as designed. But the plaintiffs' lawyers wanted to extort Chevron Corporation.
Eso es mal, porque como se sabe, no saben ustedes, el gobierno aquí probablemente nunca va a pagar cualquier sentencia. En contraste, Texaco puede pagar.
So, they agreed not to sue the Republic of Ecuador for failing to conduct its share of the cleanup. And the plaintiffs' lawyers lobbied President Correa to bring baseless criminal prosecutions against all the individuals who signed the settlement and release agreements, particularly 2 former TexPet employees.
Entonces, el presidente cree que si hacemos un poquito de esfuerzo ante el Ministerio Público, el fiscal va a ceder y va a reabrir esa investigación por el fraude del contrato entre Texaco y el Estado ecuatoriano.
Ecuadorian prosecutors had on multiple occasions found no evidence of any crime whatsoever related to TexPet's remediation or the settlement and release agreements. Yet, eventually, the government of Ecuador caved to the plaintiffs' pressure. Ecuadorian prosecutor Washington Pesantes, who previously rejected these same charges, reopened the criminal investigation in 2008 and then promptly recused himself. But just as before, the baseless charges were dismissed. And the sham criminal charges were revealed for what they were: just another part of the plaintiff's lawyer's strategy to force Chevron Corporation to settle by targeting its employees.
A los que impulsaron esto, a los que defendieron esto, aquí en la misma fosa, porque ahí es donde deben. A ti te lo entierran hoy, a ti te lo van a enterrar, a ti te lo entierran hoy, a ti te lo van a enterrar, a ti te lo entierran hoy, a ti te lo van a enterrar. Murió el competite y lo entierran hoy. ¿Cómo? Murió el competite y lo entierran hoy. Ay, dice.
Approximately 100,000 Cofan inhabited the banks along the Agua Rico River before the arrival of Spanish explorers. But disease and war took their toll. By 1611, perhaps only 15,000 Cofan had survived. Throughout the region, diseases like smallpox and measles, as well as confinement in rubber camps, caused further declines in indigenous Ecuadorian populations during the late 19th and early 20th centuries. By 1947, a census estimated the Cofan population in Ecuador at just 517 individuals. Beginning in the mid-19th century, the government of Ecuador pursued aggressive colonization, acculturation, and assimilation policies. Because the Ecuadorian government did not recognize indigenous land rights, the government also initiated a massive transfer of native lands to migrating settlers. Since 1955, Ecuador's indigenous populations in the former concession area have grown, primarily due to the increased accessibility of medical care. For instance, the Cofan population has increased by approximately 200% from its 1947 level. As Ecuadorian plaintiff Javier Piaguaye testified, the Sicopai population is also increasing.
Has the population of the Sicopai increased from 1971 to the present?
Desde 1971 hasta el presente, ¿ha aumentado la población de los Sicopai?
Sí, ahora está aumentando recién.
¿Está aumentando aquí? ¿Recién?
Sí, están aumentando.
Yes, it is increasing. It's increasing.
In the movie Crude, what really happened is ignored, and Donziger invents his own history. And Donziger carefully controls and manipulates indigenous voices to publicize his false narratives.
Eso fue bueno. I think he needs to write this out again. I don't think that was good, to be perfectly frank. You got to control this guy and get him up to speed. Seriously. Because right now, I don't think he's got it down. But he can get it down, but just keep it fucking simple. Punto número uno, que ha viajado del oriente de Ecuador por pie, por canoe, por bus, por avión.
Yo soy Emergildo Criollo, soy del pueblo Cofán. Yo he viajado una larga distancia para estar aquí. Ha salido en pie, canoa, bus, en avión.
Yo era niño cuando hizo su primer pozo en Ecuador. Tenía 8 años.
Yo era niño cuando Texaco construyó el pozo Lago Agrio 1. Solo tenía 8 años.
Usted pasó 28 años en mi territorio. Yo puedo pasar 3 minutos en su territorio.
La compañía estaba en mi territorio por 28 años. Yo le pido que me escucha por solo 3 minutos.
There is no increased risk of cancer in Ecuador's Amazon region, as verified by Ecuadorian government data and peer-reviewed studies. Epidemiological studies prove that cancer mortality rates in the former concession area are not higher, and people in the former concession got cancer much less often than residents of the capital city of Quito. The plaintiff's primary expert on cancer damages testified that neither Chevron Corporation nor TexPet ever caused anybody to get cancer.
You're not offering the opinion that Chevron took any action that actually caused anybody to get cancer, correct?
No, I'm not.
And you're not offering the opinion that TexPet took any action that actually caused anybody to get cancer, correct?
No, I'm not.
Plaintiff's environmental consultant, Douglas Beltman of Stratus Consulting, likewise disavowed the plaintiff's cancer claims, testifying that Stratus never determined that any individual actually got cancer as a result of oil production. Beltman also admitted that the reports plaintiffs cite for their cancer claims are flawed. For instance, the plaintiffs secretly funded studies conducted by epidemiologist Miguel San Sebastian. But even those studies failed to conclude there is a causal link between oil production and cancer in the Oriente. Olga Lucia Gomez, a member of the plaintiff's technical team, informed the plaintiff's legal team that the people in San Carlos have lower percentages of cancer than the rest of the province of Pichincha.
Hizo un censo en la población de San Carlos al INEC y la conclusión es de que la población de San Carlos tiene menos porcentaje de cáncer que lo que se presenta en la provincia de Pichincha. Entonces esa es la última conclusión que ellos tienen para defenderse de que no viene el cáncer de San Carlos por los hidrocarburos.
¿Tiene alguna razón eso?
No, pues es un documento del INEC que se supone que es el ente que hace todos los censos acá en el Ecuador, ¿no? De mucho peso. No tenemos más que el estudio de San Sebastián para decir si hay cáncer. No tenemos más. Y según eso el estudio tiene muchas cosas cortadas, es muy sesgado.
In 2008, the plaintiffs tried to convince Dr. San Sebastian to endorse their claims regarding hundreds of excess cancer deaths attributable to Texaco. He refused, responding to them via email that they were distorting his data. When complaining that San Sebastian refused to put a number on the excess cancer cases, Donziger told his interns that if the facts don't exist, they need to make facts that help them.
We need to make facts that help us, and the facts that we need don't always exist. There's another key point about litigation. You have to get the right facts. And if they don't exist in an obvious way, you gotta go figure out how to make them. Otherwise you're gonna lose.
So that's what they did. The plaintiffs' lawyers never submitted a single medical record to the Lago Agrio court to back up their claims, because as they acknowledged in internal emails, they had none. But as plaintiff's expert David Russell testified, Donziger did not really want to know what, if anything, was causing harm to residents. His primary focus was on sticking it to Chevron. In fact, Russell saw no evidence of any widespread health effects caused by oil contamination from Texaco. Donziger just wanted to keep saying that oil was causing health harms so he could force Chevron into settling. Donziger funded a photojournalist to search for and photograph particularly sick individuals in the region so that the plaintiffs could use these people in its media campaign against Chevron. even though Russell told Donziger that the data did not support a link between these illnesses and deaths and oil operations. But Donziger ignored the facts, stating, "We need to up the ante and talk about dead children and people dying." Donziger even hatched a plan to bring kids with cancer up to Quito for a press event around Christmas in order to keep attacking and keep the pressure on Chevron Corporation. Instead of focusing on real health problems in the region caused by poor sanitation and poverty, the plaintiffs' lawyers deceived the public, using manipulation and exploitation in an attempt to win money from Chevron Corporation.
Did you at any time while you were a plaintiff's expert in Lago Agrio determine the volume of soil that needed to be remediated at any site?
No.
Did you ever determine what the cost of remediating soil at any of the sites would be?
No.
Did you ever find that any of the sites that you inspected had contamination of such an extent that it would endanger human health?
No.
Did you ever find that any of the sites that you inspected required any further remediation?
No.
While you were working as a judicial inspection expert for the plaintiffs, did you ever conclude that TexPet had failed to properly remediate one of the sites?
I didn't know.
While you were working as a judicial inspection expert for the plaintiffs, did you ever conclude that any particular site posed a risk to human health or the environment?
No.
Unable to obtain legitimate evidence to support their unfounded claims, the plaintiffs' lawyers filed falsified reports with the Ecuadorian court in Charles Kalmbacher's name, claiming Dr. Kalmbacher found a cleanup costing millions needed to be conducted.
I did not reach this conclusion, and I did not write this report.
Experts for each of the parties were supposed to submit their reports for each judicial site inspection to the court. Any discrepancies between those reports were to be resolved by independent settling experts. At the beginning of the trial, the Ecuadorian court ordered the judicial inspection of 122 oil production sites. But as David Russell, the plaintiff's former lead environmental scientist, testified under penalty of perjury, in general, Donziger was unhappy with the data that the plaintiffs were finding during the judicial inspections and the cost of conducting the inspections. By late 2004, I realized that the plaintiffs could not prove their claims because the analytical data was turning up blank for both the soil and the water samples, and the samples were not showing the contamination that Donziger wanted. Unable to obtain real evidence, Donziger turned the judicial inspections into a choreographed show to further pressure Chevron Corporation.
I mean, this is all choreographed. These inspections, I'm convinced, have nothing to do with the trial anymore. I mean, it's all about politics and arguing and bullshit and show.
When the settling experts issued their first and only report, finding that at Site Sacha 53, the risk to human health is low, and that the sample results were lower than the allowable limits, Donziger hatched a plan to abandon the remaining judicial inspections. Judge Yanez initially found there was no legal basis for the withdrawal of the judicial inspections. Donziger threatened to launch an all-out war with the judge if he did not accede to the plaintiff's lawyers' demands. The plaintiff's lawyers blackmailed Judge Yanez, threatened to file a complaint against him, and pressured him during illegal private meetings at hotels, restaurants, and Judge Yanez's home. Judge Yanez succumbed to the pressure, waiving the plaintiff's judicial inspections and permitting the appointment of a single global expert, Richard Cabrera, who the plaintiff's lawyers planned to secretly control. The plaintiff's lawyers could not risk the completion of the judicial inspection process, nor a truly independent global expert. Even their own paid experts were telling them that there was no evidence to support their claims.
All the reports are saying it's just at the pits and the stations and nothing has spread anywhere at all.
But hold on a second. You know, this is Ecuador, okay? You can say whatever you want. In the end of the day, there's 1,000 people around the courthouse, you're gonna get what you want. We have enough. to get money, to win.
One by one, the plaintiff's leading experts have come forward to disavow their work on the case and to tell the truth about the plaintiff's scientifically bankrupt claims. Apart from destroying the proceeding, all of us, your attorneys, might go to jail. Plaintiff's Ecuadorian lawyer Julio Prieto warned the rest of the plaintiff's legal team in 2010. Prieto feared that Chevron Corporation would discover plaintiff's years-long criminal scheme involving falsification of documents, bribery, and collusion. Plaintiff's lawyers corrupted the supposedly independent court-appointed expert Richard Cabrera and wrote his report. The Ecuadorian court appointed Richard Cabrera to conduct an independent global assessment of the former concession area, ordering him to perform his duties with complete impartiality and independence vis-a-vis the parties.
He sido nombrado perito para el examen pericial global. Yo soy este momento la máxima autoridad en este examen pericial. Las muestras, los análisis que se hagan serán los únicos valederos para este caso.
Yet that same day, the plaintiff's lead U.S. lawyer, Stephen Donziger, arranged to pay Cabrera, who the plaintiffs referred to by the codename WOW, tens of thousands of dollars in bribes from a secret bank account. Donziger handpicked Cabrera because he was the perfect foil for Chevron and pressured the Ecuadorian judge to appoint Cabrera. Just before Cabrera was appointed, the plaintiff's lawyers and consultants held a secret meeting with him.
Mi nombre es Richard Cabrera, soy ingeniero geólogo.
At this secret meeting, the plaintiff's team boasted that they would do Cabrera's work for him and that Chevron Corporation would not be allowed to participate.
Apoyar al perito en la redacción del informe. Y aquí sí queremos el apoyo de todo el equipo técnico nuestro, de expertos, científicos, abogados, politólogos, para que todos aportemos ese informe. O sea, vean, la carga no va a ser del perito. La carga la llevamos entre todos. Y queremos el compromiso de todos para este proceso.
Tiene una pregunta. El informe final, ella dice, el informe final va a estar elaborado solamente por el perito.
El perito lo que va a hacer es dar su criterio y firmar el informe y revisarlo. Pero nosotros todos tenemos que aportar ese informe. Juntos. ¿Sí?
Pero no, Chevron no.
But not Chevron.
The plaintiff's lawyers even drafted a letter filed with the Ecuadorian court in Cabrera's name, stating, "I should clarify that I do not have any relation or agreements with the plaintiff, and it seems to me to be an insult against me that I should be linked with the attorneys for the plaintiffs."
Do you see that in Exhibit 107, Mr. Cabrera states to the Ecuadorian court, quote, "I should clarify that I do not have any relation or agreement with the plaintiff, and it seems to me to be an insult against me that I should be linked with the attorneys of the plaintiffs," close quote. Do you see that?
Yes.
That statement was false, correct?
I don't think it's an accurate statement.
You do not think it's an accurate statement?
No.
While paying Cabrera more than $300,000 to pose as the court's independent expert, Donziger hired U.S. contractors at Stratus Consulting to secretly ghostwrite Cabrera's report. But the plaintiff's lawyers didn't stop there. In an attempt to cover up the fact that they secretly ghostwrote Cabrera's report, the plaintiff's lawyers objected to the same report they had just written, claiming it was unjustly favorable to Chevron. They then ghostwrote, in Cabrera's name, Cabrera's response to their fake objections, making sure to clean up the language to make it sound more like Cabrera. When Joseph Cohn, a North American lawyer who financed the Lago Agrio litigation, learned the extent of the fraud, he wrote, "I am also shocked by recent disclosures concerning the potentially improper and unethical, if not illegal, contacts with the court-appointed expert, Mr. Cabrera. We now find out that there may have been extensive systematic contacts, orchestrated by Donziger and with your participation and agreement, which have threatened the entire case. And of course, we found out about it in part as a result of the utter stupidity, arrogance, and conceit of inviting a film to be made documenting this improper conduct. In March 2013, Douglas Beltman, the Stratus officer in charge of the Ecuador project, came clean about his and Stratus's role in drafting the Cabrera report. Beltman admitted under penalty of perjury that he and his team at Stratus wrote the Cabrera report and almost half of the annexes attached to the report, and that the entire global assessment was carried out at the direction of Donziger and the other plaintiffs' attorneys. Beltman testified, "The damages assessment in the Cabrera report and Cabrera response are tainted. Therefore, I disavow any and all findings and conclusions in all of my reports and testimony on the Ecuador project. I deeply regret that I allowed myself and my company to be used in the Lago Agrio litigation in the way that we were, as detailed throughout this declaration." Plaintiff's attorney, Jeff Schinder, testified that he withdrew as a result of learning from Beltman that Stratus had written the Cabrera report.
If my interview with Doug Beltman concluded at 5 o'clock in the afternoon on the 17th, by 5 o'clock and 1 second, I wanted out. I'm no expert in Ecuadorian process, but if you have an independent expert who's being proffered to justify a significant damage finding against a major corporation, that if his independence is compromised in a way that was not disclosed, not transparent, I think that's per se improper. I was physically impacted by what Mr. Beltman told me. It made me sick. I remember saying that. Refreshed. I remember where I was standing. I was in an airport talking to him. It made me sick.
In a letter drafted to his co-counsel, Donziger admitted that the traditional Ecuadorian law perspective would hold that the level of collaboration between one party and the expert is problematic and improper. By working so closely with our local counsel and Stratus, Cabrera violated his duties to the court. And the CEO of Burford Capital, which had agreed to provide up to $15 million in funding for the Lago Agrio litigation, testified under penalty of perjury that there is absolutely no question that Burford would not have invested in the litigation had we known the whole truth about Cabrera, and voluntarily gave up any and all claims to any recovery, even if the plaintiffs in the Lago Agrio litigation are ultimately successful in extorting some payment out of Chevron. 8 U.S. federal courts have found elements of crime or fraud in the plaintiff's attorney's conduct. Reflecting the views of courts across the country, the U.S. District Court for the Western District of North Carolina wrote, "While this court is unfamiliar with the practices of the Ecuadorian judicial system, the court must believe that the concept of fraud is universal, and that what has blatantly occurred in this matter would in fact be considered fraud by any court." Wilson Fajardo, brother to plaintiff's lawyer Pablo Fajardo, was murdered in Ecuador by 3 attackers in an alcohol-fueled ambush on August 9, 2004. 2 days later, Pablo Fajardo gave Ecuadorian prosecutors a signed statement, attesting that his brother had been murdered by 3 locals, one of whom had previously attempted to stab Wilson only days earlier during an altercation at a friend's house. According to Fajardo, at approximately midnight, my brother was taken by Paul and Johnny Zambrano. They met up with Pedro Batista, and the 3 individuals took my brother to the place where they killed him. My brother was first tortured, beaten against the wall, and then shot. He then asked Ecuadorian prosecutors to issue an arrest warrant for the 3 attackers, none of whom have any association with Texaco. Despite knowing Texaco had nothing to do with the murder, The outtakes from the movie Crude capture Fajardo rehearsing a different story after becoming the plaintiff's lead Ecuadorian lawyer in 2006.
Cuando mataron a mi hermano, la gente decía que a quien buscaban era a mí.
Es decir, la gente de la ciudad hicieron.
Sí. Cuando mataron a mi hermano, la gente de Susufindi, de mi pueblo. Cuando mataron a mi hermano, la gente de mi pueblo decían que a quien buscaban era a mí.
¿Quién? Los asesinos.
Ya. Cuando mataron a mi hermano, la gente de Susufindi decía que los asesinos a quien buscaban era a mí. Eran sicarios. Cuando mataron a mi hermano, la gente de Susufindi decía que los sicarios a quien buscaban era a mí.
Fajardo used Crude to shamelessly exploit his brother's violent death to manipulate public opinion for financial gain.
Es ese lugar donde está sepultado mi hermano. Tenía 28 años de edad. Mi hermano murió 8 días antes de que realicemos la primera inspección judicial del caso Texaco. Alguna vez un informe militar le dijeron a uno de mis hermanos que al que buscaban era a mí.
Plaintiff's North American lawyer, Stephen Donziger, believes that Ecuadorian courts are corrupt.
All the judges here are corrupt.
They're all corrupt. It's their birthright to be corrupt. Why? Because they get paid so little. You know, it's the culture. It's disgusting.
So instead of trying to participate in a fair trial, Donziger set out to exploit the weaknesses of the Ecuadorian system to his advantage through bribes, fear, and public pressure.
Right.
Hold on a second. You know, this is Ecuador. Okay? You say whatever you want. In the end of the day, if there's 1,000 people around the courthouse, you're going to get what you want. We have concluded that we need to do more politically to control the court, to pressure the court. We believe they make decisions based on who they fear the most, not based on what the law should dictate. But it's a critically important moment because we want to send a message to the court that don't fuck with us anymore, not now and not later and never.
Plaintiffs' lawyers threatened judges, falsified expert reports, bribed court officials, and conspired with the supposedly independent court expert to commit perjury, all with the goal of extorting money from Chevron Corporation. In contrast, Chevron Corporation never engaged in these corrupt practices. The plaintiff's corruption extended to the 188-page, $18.2 billion judgment in their favor. Text from 6 of the plaintiff's internal documents appear verbatim in the judgment, documents that were never presented legally to the Ecuadorian court. One federal court in the United States found, Chevron has shown to anyone with common sense that the judgment is a blatant cut-and-paste exercise. In 2012, Alberto Guerra, a former presiding judge of the Lago Agrio case, came forward with the truth. The plaintiff's lawyers made a secret arrangement with Judge Zambrano when he took over the case. For $1,000 per month, Guerra would ghostwrite Zambrano's orders and steer the case in plaintiff's favor. Alberto Guerra produced a computer containing draft orders and records of payments from the plaintiff's team and Zambrano for his work as Zambrano's ghostwriter. In a declaration made under penalty of perjury, Guerra confirmed that this scheme extended to the judgment. The reason the plaintiff's documents appear in the judgment is because they arranged with Judge Zambrano to write it themselves, promising Zambrano $500,000 when they collected on the judgment. The plaintiff's own Ecuadorian law expert, Raul Rosero, testified under oath that, assuming Guerra's account is true, Zambrano and the plaintiff's lawyers are criminals.
Accepting Mr. Guerra's declaration as true as you have for purposes of your expert report, do you agree with me that Judge Zambrano has committed the crime of bribery?
Entonces, si aceptamos la declaración del señor Guerra como verdadera para los propósitos de su informe pericial, Entonces, ¿usted coincide conmigo de que el juez Zambrano cometió el delito de cohecho?
Objection, scope.
Objeto, alcance.
You may answer.
Puede responder.
En el evento que sea cierto,
In case that is true,
cometió cohecho Zambrano.
Zambrano committed the act of bribery.
And accepting the facts in the Guerra Declaration as true, Mr. Fajardo, who offered to pay money to Judge Zambrano and to Mr. Guerra, has also committed the crime of robbery, correct?
Y si aceptamos como verdaderos, como verídicos, los hechos dispuestos en la declaración de guerra, entonces el señor Fajardo, que según esa declaración ofreció pagarle dinero al juez Zambrano y al señor Guerra también, entonces Fajardo también cometió el delito de cohecho.
Objection, scope.
Objeto, alcance.
Aunque no está dentro de lo que me preguntaron en el informe, habrían cometido cohecho todas las personas que estuvieron relacionadas a ese hecho de ofrecer dinero al juez a cambio de la expedición.
Even though it is outside the scope of what I was asked, all individuals who participated in that act of giving money to the judge in exchange for the issuance of
a cambio de la expedición de una sentencia favorable.
Of a favorable judgment.
Are guilty of bribery, correct?
¿Serían culpables de cohecho, correcto?
Sí.
Yes.
In fact, Zambrano was removed from the Ecuadorian judiciary for illegally arranging the release of accused drug traffickers. Yet, the plaintiff's lawyers' corruption continues as they attempt to cover up their scheme. Judge Zambrano himself has continued to meet with plaintiff's lawyers on multiple occasions. The ties between plaintiff's lawyers and Judge Zambrano offer more clear evidence of a tainted and corrupt process, an illegal scheme that produced the fraudulent $18.2 billion judgment against Chevron in Ecuador.